Welcome back to Talk Jamaica here on Talk Jamaica Radio. We are streaming live on www.talkjamaicaradio.com. Also, we are streaming at caribbean.com. My name is Ralston Chamberlain and my co-host is Ricardo Brooks. Listeners, the constitutional crisis now looms following Friday's landmark ruling by the Constitutional Court that the use by opposition leader Andrew Holness of using pre-signed letters of resignation to revoke the appointment of Senators Arthur Williams and Christopher Tufton was indeed unconstitutional. The former senators were replaced by Jamaica College Principal Will Reed and Business Executive Dr. Nigel Clark.
The pre-signed letters were prepared on Mr. Holness's request by the claimant Arthur Williams. Already, the government has asked the Attorney General to look into the matter, given that the court's ruling indicates that both Mr. Williams and Dr. Tufton are still senators. To give us some analysis on the matter, we're joined by analyst and attorney at law Marc Jones and attorney at law Bert Samuels. Good afternoon, gentlemen. Welcome to the program.
Good afternoon.
Good afternoon to your new listeners. Thank you.
All right, Mr. Samuels, let me start with you. Your immediate reaction to the development coming out of the Constitutional Court.
Well, as an attorney, it was a very important decision. It was the first of its kind, which ruled on, appointments to the upper house. And I was, it led me to feel that we could be entering a constitutional crisis, mainly because the attorneys representing Mr. Holness at the end of the case tried to say that this was not compelling, as it were, and that the leader of the opposition need not, do what is the decent thing. They did that because the court made a declaration. It did not give an injunction. But there's more to that in terms of law.
Mm-hmm. Marc Jones, your reaction?
Yes, well, my reaction is that I wasn't necessarily surprised by the outcome of the case when the act was actually done in 2013, that the use of the letters and it came to light in the media. It struck me as something that could undermine the independence of a legislative body. And so having the court essentially find that as the position, I was not necessarily surprised. I am now more interested in the implications of the ruling and where we go from here.
Mm-hmm. Mr. Samuels, you noted that there is a difference between a declaration and injunction. For the purposes of our listeners, could you clarify that difference?
Okay. Historically, the Crown, the Governor General represents the Crown. There have always been laws to protect the Crown from being forced by the courts to do anything. So that in the Crown Proceedings Act, there's a section there which says, whereas between other parties, not the Crown, an injunction may be awarded by the court. When they're in place of an injunction, you'll have a declaration. Now, there's a convention surrounding when the court makes a declaration which declares something to be A, B, and C. The convention is that the functionaries, be it ministers of government or civil servants or whoever, leader of the opposition, the Governor General, they will always follow the declaration. So the declaration is not, as it were, mandatory. It doesn't say you have to do anything. It simply declares what the law is, and the decent politicians will follow.
Mm-hmm. Yes, and I just to agree with that. It's not even so much that the other arms of the government would just follow. They also, this can also be looked at in terms of the structure of our government. There are three arms: judicial branch, which is the courts, the legislative branch, which is Parliament and the Senate, and the executive, which is the government, Governor General, Prime Minister. One branch of government has now indicated its view of the matter, and this is the law interpreting branch of the government. And so the other part of the government, quite apart even from just convention, although this supports the convention, the other branches of government will generally follow what the judicial branch has said in terms of a declaration.
But let me ask you, gentlemen, and let me start with Mr. Samuels first, because we speak about whether or not the court gave any directive, right? And they did not automatically render the appointment of Senators Reid and Clark null and void. What do you think will happen to them now in this instance?
Well, it's a question of logic, and it doesn't require lawyers, because if the appointments were not properly made, then they were not properly in the upper house. Although there would have been another constitutional crisis. What about the laws they have voted on? But there are provisions in the Constitution which says that even if a member is declared not to be a member down the road, it doesn't void the legislation that he voted on. And that was a very common sense and sensible thing for the Constitution to provide for. So lucky we that the laws which Reid and the other member voted on are not going to be voided. But I expect them not to turn up for the Senate at the next sitting.
Yes, well, I agree with that. Yes, I agree with that position also. But then, we always have to think about the other side of the coin. What if the senators do not want to resign? What if Clark and Tufton refuse to? Clark and Reid refuse to resign? Yes, in my view, that would probably necessitate either going back to court on an application for the court to determine the validity of their appointment, because this judgment, as Ralston pointed out, doesn't touch on the question of the senators that are currently in place. This judgment really just touches the question of whether their removal was unlawful. So if they refuse to go back to court, then perhaps if Mr. Williams and Mr. Tufton want to push the matter, they could perhaps apply again for the court to determine the validity of the current appointment. And that logical answer that Mr. Samuels gave would be the argument to make, so I can see that. But then perhaps it may not even require a legal response. There's also a political avenue, the way that this could be resolved. I suspect I have no contacts or moles in the meeting rooms, but I suspect a lot of flurrying and meetings going on behind the scenes to try and find some way to resolve this without going back to court.
But one interesting feature of this, what I'm calling this almost this circus, is that the leader of the opposition has said, post the judgment, that he was wrongly advised on the constitutionality of the arrangement with the letters by Williams himself. He's passed the buck to his attorney.
Well, Bert, as you know, whenever anything goes wrong, the clients are the first to blame the attorneys. So that is completely unsurprising.
I think, well, apart from constitutionality, the letters in themselves was an indecent arrangement.
Yes, I agree. Quite apart from any partisan politics, I think the arrangement was an unethical one, and that's how I felt from the beginning about this matter.
So let me ask, my lower staff that way.
Let me ask, because the Governor General would have received the letters of resignation. Did the Governor General have any powers to say to Mr. Holness, what you are doing is in breach of the Constitution and improper?
No, but remember, when the Governor General got them, they were recently dated. They were dated November, I think, 14th, 2013. So he could not look beyond that date. He got what was seemingly on the face of it, and the court did say on the face of it, these are clear resignation letters on the face of it. The court was able to go beyond it, but the Governor General would not be expected to go beyond that.
No, his office is a constitutional function, and so once he follows the procedure under the Constitution and everything appears at face, it is not for the office of the Governor General to look behind it or to go to substantive merits. That's for the other branch of the government, as I alluded to, the judiciary.
Let me ask you then, Marc. Does this mean then that in effect senators have a full term of 5 years appointment? Because in practice we've been practicing this way where if the Prime Minister or the opposition leader, for whatever reason, needs a vacancy in the Senate, they simply ask a senator to leave. So can senators now refuse to resign until the life of the parliament.
No, that makes the decision very, very interesting, because what the court decided on was that the office of a senator and a member of parliament has security of tenure. There is no provision for the leader of the opposition or the prime minister to terminate any member. It cannot be terminated. They can't be forced out of office. So the party whip has been shortened.
Yes.
But it does. My view is that I've always said that is always a good idea, because if you have a good leader of the opposition which has become wayward, and similarly a good prime minister which has become wayward, and is seeking to compel you to make bad laws, to, as it were, end our democracy with bad laws, then part of the checks and balances that the court has now reinforced is that when they are nominated in the upper house or elected in the lower house, they cannot be controlled. In other words, our legislature has been given and riveted with a security of tenure flowing from this judgment.
Yes, I agree. I mean, the reasoning of the decision is that the senator's resignation must be of his own free will. And so he can't even, the decision even goes a bit further. Like, he can't even, as in this case, agree with someone that they can determine what he did, because technically the senators agreed with Holness that you can determine my tenure. The court can say that is not even in the power of the senator. He must always remain free of free will to determine the time when he's going to resign.
So it is a new day for all of the opposition, a new day for the Prime Minister to learn that there's security in the Constitution.
Yes, and the thing is, the Senate has, I mean, I've heard in some quarters, some of the commentary in response to this has been, oh, well, the Senate is a rubber stamp, and so on and so on. This judgment, and one implication, as we are now recognizing and discussing, is that perhaps the Senate is not so much a rubber stamp, at least in law, because now the independence of the senators have been reaffirmed. As to what they use their independence to do now, that's a different question on politics. But in law.
But last week, Clark, appointed by the opposition, refused to vote with the majority of the opposition. So, he has been using that independence somewhat.
Yes, and this leads to a very interesting issue down the road in April when the CCJ vote comes up, where the government only needs one opposition senator to side with them. Now the senators, as it were, have been released.
Yeah, but I'm adding to that consideration that Williams has not said that he's going back to the Senate. It seems as though he's considering whether he will give up his true resignation now, or he will go there and become more independent than he was thought to be.
Yes. So, interesting days ahead. We haven't heard from Tufton as to what his decision is, but we will see.
But let me ask you this, Bert Summers, because I hear you talk about talking about that there's no power within the leader of the opposition or the prime minister to remove the senators. Could it then be that, having read the Constitution and not see that that he had any power, Mr. Holness and Mr. Williams then came up with the crafting of this letter? Because having said, okay, we don't have any power to remove them, if they voted against the party line, then this is our backup plan.
Well, are you saying now, if you don't take the party, what will that do in the future for persons in the Senate who do not wish to take the party line? That is where, we're going to have issues of governance, because it is now clear that the senators can be independent, and, their career would be as long as the appointment. But, it's become very interesting to see whether the rubber stamp, as my friend has said, is going to continue to operate the way it has.
Yes. Well, Ralston, could you repeat the question? It was a little grainy on this end.
No, I was asking, having read the Constitution, let's just say having read the Constitution and recognized that Mr. Holness had no power to remove the senators had they voted for the CCG. It was having that in the back of his mind. They went ahead and crafted this letter of resignation.
Well, Ralston, you're asking a lawyer to imply what was in someone else's mind and the decision. I will refrain from implying that, but I would just like to add, though, that in fairness, okay, yes, the scheme itself was unethical, and I think anyone looking on it would have an unethical feeling about putting it in place. But as to whether they specifically knew at the time the letters were crafted that, this could be in breach of the Constitution, I'm not ready to make that link to imply that specific knowledge on their part. As Mr. Samuels has quite rightly pointed out, this is a novel judgment. It's a novel court case. It's a new judgment. It's a new development on the constitutional landscape. So given the newness of it, I'm not quite willing to imply that they specifically set out from the beginning to breach the Constitution.
But let me add this. Remember, Williams argued that those documents were created only for the vote of the CCJ. What Williams' complaint is, the Holness was now using it for another reason.
Yeah.
And that is what he parted company with. Now, the court said, we are not interested to know the reason because we are upholding the Constitution. We are not interested to know what purpose it was for. In itself, it is against public, against the legal unconstitution, against public policy. So those internal arrangements, it shows you that the political parties in Jamaica cannot come to agreements outside of our Constitution. I think that's what the judgment enforces.
Yes, I agree. Explicit arrangements to circumvent the principles of the Constitution then.
All right, so we're up on a break. We're speaking to Bert Samuels and Marc Jones, attorneys at law. We're going to take the break, listeners, and then we'll return. Stay with us.
Grandeur Mail carries the trendiest, unique, and unusual clothing items at affordable prices. We are the one-stop spot where we can get everything to suit your needs. We have various brand names such as Massimo Dutti, Paul Smith, Aeropostale, Guess, Pull & Bear, Tommy Hilfiger, and many more. We also carry our very own line of clothing in the store. We offer good customer service that will keep you wanting to come back, and not only to shop, but for the laughter and the warm comfort there is. We're located at Grandeur Plaza, 38 Constant Spring Road, Kingston 10, Jamaica. Telephone 754-8618, 410-5787. Follow us on Twitter at Mail Grandeur. Follow us on Instagram and Facebook at Grandeur Mail. Email us at grandeur.mail@gmail.com or check out our website at www.grandeurjamaica.com.
Sure Stitch Embroidery specializes in artwork, digitizing, embroidery, and screen printing on a wide variety of items to suit your needs. Visit us at 8 St. James Avenue, Kingston 5 off Maxfield Avenue. You can speak to the manager, Latoya Stewart, who will be more than happy to assist you. Opening hours are Monday to Friday, 9 a.m. to 5 p.m. Telephone 754-5345 or cell 320-7308. Email surestitch2009@yahoo.com.
Welcome back to Talk Jamaica. We are discussing the recent ruling by the Constitutional Court, in effect nullifying those undated letters of resignation coming out of the Jamaica Labour Party. Our guest attorneys at law, Marc Jones and Bert Samuels. I want to pick up on the matter of whether or not Mr. Holness needs to resign, because much has been made about the fact that a court has found his actions unconstitutional. Therefore, he has breached the supreme law, and he is no longer competent or fit to be the leader of the opposition. Your take on that, Mr. Samuels, first as a constitutional issue and then as a political issue?
Well, no, he continues to be the leader of the opposition. If we are to borrow the convention in the in a Westminster-style government, I would hardly see a minister, a leader of the opposition in England surviving a court description of his action to be unlawful, unconstitutional, against public policy. He would have to really reconsider whether he could withstand the press, he could withstand the opposition, he could withstand the questions in Parliament, and maybe in that Parliament, the leader of the opposition would consider bowing out. If you want me to give my prediction, that won't happen anytime in Jamaica. No, the matters like these do not lead to resignations in Jamaica. Constitutionally, he continues to be the leader of the opposition, and politically, my experience has shown that he will not die a political death over this.
Yes, I quite agree. Interestingly, on the constitutional dimension, just to reinforce what Mr. Samuels is saying, that this judgment does not impinge on his constitutional capacity. If you look at the actual judgment, he's actually sued in his personal capacity. It is Arthur Williams versus Andrew Holness. So the suit does not seem to have been brought against him in his capacity as leader of opposition. Sure, he did the actions and so forth in that capacity, but he was sued in a private capacity. So that apart, I don't think that this ruling has the effect of somehow depriving him of his constitutional status as leader of the opposition. As to the political dimension of it, from my perspective, I think it is a serious thing and it ought to deserve a serious consideration as to whether this leader of opposition has acted in an unconstitutional way. The court has found that. I don't know if it will reach a threshold of it being something that would require him to resign, as Mr. Samuels is saying, but it is certainly an issue that needs to be considered by electors, by voters, by civil society. So it is a serious issue.
Let me ask you this, Marc Jones, attorney at law. What role does the Attorney General play in this ruling going forward?
Well, the Attorney General was actually a party to the case in the court. Even though they weren't sued, the Constitution actually guarantees the Attorney General a role in constitutional cases like this to make submissions to the court. That suggests that the Attorney General has a public interest function to advise on what the proper route is. And so I would expect that the Attorney General's chambers, if they haven't already done it already, would have gone through the ruling from Friday and analyzed it and look at the implications and come up with some recommendations or some position as to how this would affect the process going forward. So in a sum, the Attorney General's role at this point, as I understand it, would be in an advisory capacity.
And let me ask you this one question, Mr. Samuels. If in the event Mr. Will Reed and Mr. Clark decides to sit in the Parliament, would they be in breach of what the court has, well, although the court has not made a pronouncement, if they decide that they're going to continue to sit in the Parliament, would this then be that they're in breach of some order from the court?
Well, that's an interesting question, because I think they would naturally be in touch with Mr. Holness on Friday afternoon to find out first whether he wishes for them to continue. Now, if they are told continue, they expect them to turn up in Parliament, and that is when we would have a constitutional crisis, because the Attorney General, no doubt, has advised the Governor General that those resignation letters belong to his waste paper basket because they have been voided by a court. And, there is a limit on the amount of senators that the opposition can have. I think it's 8 and the government 13. So that's a constitutional crisis. There will be 10 senators, de facto coming to court, to the Parliament, I mean. No, that's going to create a real crisis if they turn up for the next sitting.
Yes, and it would be an irresponsible crisis too, because the court has clearly said that the Williams and Tufton were unlawfully removed. And so if I were in Mr. Clark's or Mr. Reed's position, I would even necessarily need to speak with the leader of the opposition as my own independent judgment and values and ethics. I cannot continue to show up in the chamber to debate and to make laws when my position is precarious, verging on the untenable. So I think the honorable thing to do would be to step down of their own volition. If not, then it would lead to the crisis, as Mr. Samuels is alluding. The matter would end up back in court, and that could not be a good thing for the jails here at this time, to have two court cases over this issue so close to when a general election is looming.
Mm-hmm. Finally, first to you, Mark, and then to Mr. Bert Samuels, Mark Jones. Your position on Jamaica accepting the appellate jurisdiction of the CCJ?
Oh, my position on that?
Yes.
Yes, well, I think my position is an evolving one, and I think it continues to evolve. Some of the arguments that I have heard against the CCJ, I think, are misconceived, but I can understand the reluctance to go there. I think I have actually appeared before the CCJ once before, and having seen how they dealt with a case, I was impressed. So I know that it's not that the court is somehow of a lesser quality than the Privy Council, but I think there are other issues that could come into play. So I just caution the deliberation on it. Either way, I am not vested either way. It's an evolving position.
Mm-hmm. Bert?
My position is this: being a Pan-Africanist, being someone that is anti-monarchical, I cannot agree that a court which is advisor to Her Majesty in England is a court that we should, out of self-respect, want to maintain. I am a graduate of the University of the West Indies, a regional university, a regional court I support, and I think that the sooner the better for our pride and dignity as a sovereign nation to collectively, and we've been one of the best cricket teams in the world, we can have one of the best courts in the world.
Very, very well said, and we're going to leave it there on that note. Mark Jones, Bert Samuels, attorneys at law, thank you so very much for joining us and sharing with us.
A pleasure. Thank you.
All right.